Did you know that there are federal and state laws with mandates for taking adverse employment actions on information found in consumer reports? The Fair Credit Reporting Act, commonly referred to as the FCRA, imposes requirements for employers when they're considering taking an adverse employment action against a prospective or current employee based on information in a consumer report. This is known as the pre-adverse and adverse action process. So first, let's define what an adverse employment action means. An adverse employment action can include, but is not limited to, rescinding a job offer, terminating employment, pay reduction, or demotion to a lesser position. If an employer is considering taking an adverse employment action based on information found in a consumer report, the first thing that they need to do is to send a pre-adverse notice to the consumer. The pre-adverse notice should contain all of the following documents. There may be copies of other applicable documents as well, depending on the consumer's state of residence. Within the pre-adverse letter, the following information should also be included. After issuing the pre-adverse action, employers must make a reasonable amount of time prior to issuing the adverse action. The Federal Trade Commission recognizes 5 business days as an acceptable waiting period. Please be aware, some cities and states like California may require a longer waiting period. Once the waiting period is over, it's generally safe for an employer to proceed with issuing the adverse action notice if the consumer did not file a dispute. The adverse action should contain the following documents. The name of the consumer reporting agency that produced the report is also very important so that the potential client could reach out and ask any questions that they might need to. A statement mentioning the Section 612 of the FCRA is also very important. Validity's consumer inquiry team has procedures in place for handling inquiries related to pre-adverse and adverse actions. If a consumer contacts our team regarding the pre-adverse letter, we will respond to them within 1 business day. Should the consumer decide to file a dispute, we will open a dispute and begin the reinvestigation. The employer will always receive a notification if we've opened a dispute. If the consumer does not need to file a dispute, we may still notify the employer that the consumer contacted our team, depending on the nature of the inquiry. Failure to comply with pre-adverse action and adverse action requirements on your organization can open you up to legal risks such as serial litigations and class action lawsuits. In 2023, a Missouri plaintiff filed several lawsuits against various employers. One of the complaints was that the plaintiff claimed they were not provided a copy of their consumer report, which does violate the adverse action requirements. A company in Florida agreed to pay over $150,000 to resolve a claim that they violated the FCRA whenever they were taking adverse action based on their consumer reports. The plaintiffs claimed that the company failed to provide the consumer reports with pre-adverse notice prior to taking the adverse action, therefore violating the FCRA. To minimize legal risks, it's recommended that employers review their pre-adverse and adverse action procedures with a qualified legal counsel to ensure that their practices are compliant with applicable federal and state laws. While we cannot provide legal advice, we do encourage our clients to direct their consumers to our consumer inquiry team regarding any questions about their consumer report. And we are always happy to help consumers understand the information found in their report.
Now that's validation.